Welcome back to the Blackletter podcast. We set out to create an entertaining and exciting podcast about law and business. Blackletter, the name, comes from the Gothic typeset. Over time, Blackletter became the only font that English law books were printed in. It made it harder for kind of the common person to understand what the English law books said. Blackletter came to represent something that was law, that was set in stone, that was sort of old and a well-settled fundamental principle of law. We're here to demystify black-letter law. We're here to demystify things that happen in business and law and where those two meet. And I hope you have fun listening. Welcome back to the Blackletter podcast. Thanks for joining us again. With me, I have Tony Brown, Antonio Brown, of a patent monetization expert. Last time he shared kind of what patent monetization is, how he started his company, how he left his firm, Jenner & Block, and took a big leap many years ago. And today he's going to talk about an example or something that's happened in his career that will kind of bring this down to earth for everybody so you can understand what Tony's gone through and what he does now. So Tony, I'm going to kick it off to you. We've given you some time to think about this. So if you have any thoughts, I'll go ahead and share with our listeners. Be great.
Sure. Well, I've got a couple of war stories on the patent litigation front. One of my initial big cases was against Intel, and we had a patent that was owned by a company called IMS that was a competitor of Intel. They made a chip that competed with Intel's chip. They were much smaller, and
Okay.
I acquired ownership of the patent from the company. They basically didn't have the resources to enforce the patent. They were a very small company, and Intel had made it very hard for them to compete by basically making customers avoid their chips. So they basically said, to their customer base, don't buy chips from IMS. And so they had a tough road to hoe. And I acquired the patent, and the patent had to do with what's called backward compatibility. So as Intel made new chips, those chips had to be able to run with older computers. So there was a feature in them that allowed you to go to have backward compatibility with prior models of computers. It's a very important patent because it applied to virtually all of their chips, and it was they were multi-billion-dollar sales. So we filed a lawsuit against Intel for $500 million, and it got quite a bit of publicity because my company was tiny. And we asserted, we were going against one of the largest companies in the world. It got interesting because what happened with IMS is they eventually filed bankruptcy. They could not compete against Intel. They filed bankruptcy. And then there was a bankruptcy proceeding in Texas. We had filed our suit against Intel in federal court in California. There was a bankruptcy proceeding in Texas involving this company, IMS. And this mysterious Cayman Island company called Malin showed up, and they went to the trustee and they said, we want you to file an avoidance action against TechSearch, which is my company, to have the transaction where they purchased the patent canceled and have the patent go back into the estate, because we don't think TechSearch paid adequate consideration for the patent. We think the patent has a lot more value. So this company, Malin, which was from the Cayman Islands, mysteriously showed up and said to the trustee, we'll fund this action against TechSearch. We want you to go and get this patent back into the estate. Then you can auction it off to the highest bidder.
Wow.
So we did a little research, and we actually took the deposition of the person who was ostensibly the president of Malin, who was this guy sitting in the Cayman Islands with a file cabinet. That was, he had 10,000 clients there, all of them shell companies. And we found out that Intel was the owner of this company, that Intel owned Malin, which was the company that was trying to get the patent back into the estate and thereby undermine our patent infringement suit against Intel. And we went to the bankruptcy judge in Texas, and we explained to the judge that this company that was trying to bring this action to get the patent back into the estate was really Intel, a shell for Intel. And the judge went ballistic. He basically said, it's Intel was behaving improperly, and they really didn't care about whether we paid adequate consideration for the patent. They just wanted to end the lawsuit in California. And this was just a subterfuge to try to get the patent out of our hands so that we couldn't assert this claim in California in the federal patent suit. And he threw the case out. And so that's when Intel first called me a patent troll. We got a lot of publicity out of it, which was great for my
Right.
company. And because they were very upset that we were asserting this claim against. They said, "Well, you're not manufacturing anything. You're not making a product. So how can you assert claims under a patent if you're not making the product?" Well, there's nothing in the law or the Constitution which grants patent rights that says you gotta make a product in order to enforce your rights for a valuable asset that you may own. So that was a fun case, and actually the person who argued that case on summary judgment was Rob Greenspoon in
Oh,
California.
so
Yeah,
my law partner.
yeah, your law
That's
partner.
fantastic.
He argued the case against Intel on summary judgment. So that was a fun case, and
How did it go? Did Rob do a good job?
yeah. Well, Rob did a great job, and what happened was, I mean, it's kind of a long story, but what happened was the judge appointed. We had a judge who was like 90 years old who didn't understand even what a computer was. I mean, this was very, very high tech stuff. So he
Yeah.
appointed a special master who is this guy from Rand Institute to come in and evaluate the merits of the thing. And Rand Institute, believe me, they have ties with Intel. Obviously, Intel is you don't want to get on the wrong side of Intel if you're the Rand Institute. So this special master came in with a report saying, well, the patent isn't infringed because of a certain particular feature that he claims was in the product. And so we lost on summary judgment. We actually appealed the case all the way up to the Supreme Court. We went up on cert in the Supreme Court, and we lost 2-1. There 2-1 in the we lost 2-1 in the appellate court, and then we applied to cert to the Supreme Court, and we didn't get cert granted, but we went as far as we could. We ended up not winning that case, but we got a lot of it was an interesting case. We got a lot of publicity from it, and that really helped our company to grow.
Well, I mean, good news. I guess the lesson from that is not just stick to your guns, I guess, but that some good can come out of a loss. I mean, it sounds like it helped launch your company, right?
It did. I mean, the Wall Street Journal did a major article on it, and it was
Yeah.
a David and Goliath story. I really think to this day that patent was infringed. I think we should have won on the merits. I really believe that we had the right arguments and the right analysis for that case. Unfortunately, the special master didn't agree with us, and the judge really did not exercise any independent judgment in the thing. He basically relied on that was really the basis for our appeal, that it was improper for the judge to have delegated that
Yeah.
authority to the special master. That's something the judge should have decided. And if he felt there was a question of fact, it should have gone to the jury. So we really felt there were questions of fact that should have gone to the jury. We should have had a jury trial on it, which we didn't.
It's heartbreaking, and at the same time, I'm glad it helped launch the company.
Yeah.
So, good moral of the story. So, that's a little, I guess, insight into what you do. So, can you share with us any recent cases that you have that we may have heard about in the news, or anything that's popped up recently, or any big changes in the law that you think people should know about?
One of the early patent cases I had also that was kind of an interesting case. One of the first ones was a patent that it had been developed actually before the World Wide Web existed. And it basically was a technology that involved compressing an image, transmitting the image on the internet, and decompressing and displaying it. That was essentially the patent. That applies to any GIF photo or any
Right.
PDF, uh, any image that you compress and transmit and display on the other end. And this patent existed, goes back to like the mid '80s, and it was incredibly prescient in that it actually foretold what would happen on the World Wide Web and the internet as it developed. And so that was one of the first patents that I acquired the rights to. And it's an interesting story because we went out and we licensed dozens or hundreds of companies for this patent. It was a very successful licensing campaign. And the original inventors, there were two of them that were co-inventors, and one of them died, and his widow acquired the rights, and then the other one was alive. And I went to the first one, the inventor who was alive, whose name was Rosmanoff, and I tried to interest him in granting us the rights to the patent so we can enforce it. And he was so difficult to deal with, and we were just starting out, so we had virtually no track record. I could not get him to agree to give us the rights to the patent so that we could pursue it. But it turns out that there was an undivided ownership interest between him and the widow of the other inventor. So I went to the widow of the other inventor, and she was a secretary, and she was like making ends meet. And I said, I think I can make you some money here. And she said, where do I sign? So I signed her up, and then I went back to the first one. I said, well, you can't do anything without me because I own half of your patent. So you can't enforce it. I can't enforce it. So why don't we work together? So the guy finally relented. He said, okay. So I acquired the rights. I acquired the rights to the patent, and it was my first, one of my first patents. And we did so well with it. It was such a great patent. And we licensed virtually, hundreds.
So did the gentleman who didn't want to sign with you originally, was he pretty happy with the outcome?
Well,
after all of that?
He was like a Grinch. He was never happy, but the woman, the widow, was overjoyed because I made her life. I mean, she was a secretary. She was trying to make ends meet. She had health issues. She had medical bills that she, was having trouble paying. And I would send her checks every month, and she was over the moon.
That's a fantastic story. So I'll close this segment with your new tagline: Tony Brown, patent monetization, helping widows and orphans. Honestly,
I like that.
Maybe we go with that.
That's good.
Yeah. So you can have that. So Tony, when you come back next time, I'm going to ask you to give our listeners 3 kind of pieces of advice or 3 things they should know before engaging in patent monetization or before talking to either somebody like you who's looking at purchasing their patent or their portfolio, or somebody like my firm who's helping them monetize or do licensing or do litigation. So 3 big highlight things. And listeners, thank you again for joining us and joining Tony here today on the Blackletter podcast. We will be back on the next episode where Tony gives us the distilled wisdom of the ages. Download us wherever you get your podcasts, iHeartRadio, watch us on YouTube, and we'll see you next time on the Blackletter podcast.
That's all for today's episode of Blackletter. Thanks again for listening. Join us next time when we talk about more Blackletter issues in creative ways. Make sure you subscribe to the podcast so you never miss an episode, and check out our website at blackletterstudios.com.